Whether you're a plaintiff contemplating filing a lawsuit against somebody, or if you're a defendant that's been served with papers that you're being sued, you're probably going to want to know what's going to happen to you. What is the process of being part of a lawsuit? What are your risks? What are the steps you're going to expect to go through? Well, when a lawsuit is begun, it usually starts with a filing of a complaint or petition. Some jurisdictions may call it a petition. Depending on the jurisdiction you're in, the county or state, depending on where it's being filed, that's going to be the first step. That's typically filed by the plaintiff in the lawsuit, who's the one that's initiating the case. Normally, a lawsuit has to do with some type of damage or remedy that you're asking from the court. So once that's filed, the next step is that the defendant in the case, the person who's being sued, is served with those papers. That's usually done by a process server, sometimes the sheriff. In some counties, there are private parties that you can hire to serve your lawsuit. Once the court receives notice that the defendant has been served with that lawsuit, now they're on notice, and there'll be a hearing date that'll be set. And the hearing date normally is sent to both parties by mail. There's usually a court calendar online where you can look at those hearing dates. And depending upon whether or not the parties are represented by attorneys or not, we'll talk about that momentarily. The important thing is to respond at that date. That's not necessarily the date that there'll be a trial, that there'll be evidence and everything else. There's many steps that'll happen before that. Now, in some jurisdictions, there's an option to file a small claims lawsuit, where if the amount that's being sought is less than a certain amount, sometimes 10,000, 15,000, some jurisdictions it's 6,000, then the process is more streamlined. There's not a whole lot of other steps. You file a complaint or petition, the other side is served, you show up on a date, you both show your evidence or tell your story, and the judge makes a decision. That's kind of like what you'd see on a TV dramatization of lawsuits, like on People's Court or something like that, where it's a very simplified process. It's over in 20 or 30 minutes. So a small claims court is a good option for plaintiffs that have a smaller dollar amount, don't want to spend a lot on legal fees, and you can resolve it more efficiently. So now, if it's a traditional lawsuit or litigation, as it's called, the next step is going to be based on what the intentions of the plaintiff and the defendant are. For example, the plaintiff is normally going to do first what's called discovery. And discovery is a process where you request from the other side, from the defendant, certain documents, information, evidence, anything that you need to have the right information for your case. The reason for that goes as follows. You know, if you watch other types of court cases on TV, like Perry Mason or Law and Order, there's all these gotchas. There's a witness testifying in court, and then all of a sudden the other side will throw a piece of paper out there and say, look, you're lying. Well, it normally doesn't work that way, because prior to anybody ever being in court testifying on the stand or giving evidence in the actual court process, there has been a great deal of exchanging of information through a process called discovery. And discovery is where you tell the other side, look, this is what I want you to give me. All your bank statements or your corporate records or your real estate records, whatever things you want. There's also now a section of discovery called e-discovery, which is electronic discovery. Everything now is on computers, in the cloud, on email, and you can request e-discovery from the other side. Now, you'll see that the discovery process has some limitations, meaning that you can't just tell the other side, I want everything ever that you've recorded, written down, emailed, saved about you. It has to be very specific. I want these records from this year to this year. I want this profit and loss statement for your business for the year 2020. Right? I want all the emails that you sent to this employee during this period. And it has to be very specific, because Discovery is limited to what's going to be relevant to the case and what's allowable. You can ask for anything you want, but the other side can also object to it. Say, no, I don't have to give you this because it's either not allowed, not relevant, private. Some companies can defend against discovery by saying it's a work product of the company, meaning that it's private trade secrets that nobody's allowed to get. In that case, a judge can have to make a decision. Are you allowed to get this or not? Now remember, we're not attorneys. We're not giving you legal advice. We're just kind of going through what the steps you're going to have in that process. And we'll tell you a little bit later where this information comes from. So discovery is an exchange back and forth of information. And it may take 2 or 3 steps. You might ask for a batch of information. You get that and then say, okay, I see here, this is what you provided me. I need more. Or this gives me now the interest to get this other information. And remember, the defendant can also ask for discovery. If you're being sued in a lawsuit, you can also get discovery from the other side. Normally, discovery is started with a filing by a party called a motion for production, and meaning that you have to produce this evidence and you have to produce these documents or whatever it is you're asking for. That's why it's called a motion for production. Normally that's what your attorney would use to tell the other side to produce these items. Related to discovery is another step that's called interrogatories. And interrogatories is similar to discovery, but you're asking questions of the other side. You're not asking them to produce documents, you're asking them questions. Answer this question. How many times have you been to the Bahamas in the last 12 months? How many employees do you have in your company location over here? So they just have to answer it. Typed out, written, whatever it is. So it is a form of discovery, but it's interrogatories. You're interrogating the other person. It's not done in person. That's a deposition. We'll talk about that in a minute. But interrogatories are done through exchange of written responses by the other side. And again, both parties can do interrogatories of the other side. Now, the difference with interrogatories in most jurisdictions, there are limits on how many sets of interrogatories you can ask, right? And sometimes there's a limit on the number of questions. Some courts say you can have 3 sets of interrogatories, 50 questions each. So you can do 1 set of interrogatories, 50 questions, you get those answers back. That might kind of paint a picture of your case, and then you send another set of interrogatories of 50 questions, and you get that back, and now you can see what the answers are, and then that might lead you to another set. It can't go forever. You can maybe ask for an extension or ask for additional interrogatories if the person didn't answer the questions properly. That would be a motion that your attorney would make. If they feel like you did not answer the questions properly, they can force you to answer them. So what is a motion? A motion, like you've seen on TV dramas, is one side saying to the other, or one side saying to the court, I want you to make this ruling. I want you to make a ruling to tell the other side to give me these documents. I make a motion to compel the other side to give me bank statements. I make a motion for you to tell the other side to not talk to the press. So a motion is something that you direct to the court, to the judge, for them to make a ruling, for them to do something that you want them to do on your behalf. So most of these come from motions. So we've talked about discovery, exchanging documents. We've seen some discovery periods of time that have resulted in thousands and thousands of documents, big file boxes full of papers. So as a party in a case, there's some strategy. If you're given discovery request, motion for production or demand for production, do you give a lot of information or little information? Well, you can interpret what that discovery request says. Well, I want the documents from this period of time. Well, you can say, well, here's the documents that are relevant. Maybe you can leave some out. Maybe you can add too many. That's going to be where it's a strategy thing, right? The other side could say, well, you didn't give enough documents, give some more. And that can go back and forth for months. Sometimes the negotiation of what is allowable in discovery is part of the case. Another strategy some parties to a lawsuit will use is overproducing, meaning that, oh, you want some documents? Here you go. And you back up a truck and you put, 100 file boxes into the case, knowing full well the other side can't find what they're looking for. It's like needle in a haystack. You can get in trouble for that too. That might be something that is gets sanctioned because it's not in the best interest of the court. So that's discovery, interrogatories. The next thing that can happen in a case is depositions. A deposition is when a party in a case, and it doesn't have to be a plaintiff or defendant, it can be a witness, it can be an employee, it can be a third party, it can be anybody, is brought in physically to a location, usually the attorney's office that's doing the deposition. And they are asked a series of questions. And there's usually a court reporter that will take notes. The attorneys will also take notes. So if you're in a lawsuit, let's say you're getting sued, and you have a date for a deposition, on that date, you're to appear at that deposition. It's not in court. It's at a private location, usually attorney's office. And you are forced to sit there and answer the questions that the attorney asks you. Now, if you're represented by an attorney, they can be there too. They can also ask you questions for the record. And they're deposing you to get information from you. You have to answer truthfully, just like it's in court. You can't lie. In most cases, you can't refuse to answer a question. Your attorney might object if they ask a question that they don't think you should have to answer, but normally you still have to answer it. The question is that information going to be usable in court? So be prepared. That's going to be a very stressful time, because unlike being in court, you usually don't have the opportunity to not answer the question. Even if it's not usable later, that information is out there. And most times depositions become public records. So that's going to be an important thing to know about the deposition. And of course, you can do deposition of the other side. And in many cases, you can do depositions of third parties. If you have a witness in a case that has information to help your case, you can do a deposition of that person as well. The deposition becomes like a script. There's a paper document created with all the questions and answers that were asked. Usually there's limits on how long it can go. Usually it's 3 or 4 or 5 hours depending on the court. If it needs more than that, you have to come back at another time. And that deposition now becomes potential evidence in the case. So you could be deposed as a defendant. You can also depose the plaintiff and ask them questions. The reason for doing all this outside of court is so the parties gather all the information without wasting the court's time. And both parties will know where they stand in the case. Many times after discovery, interrogatories, deposition, at that point, the case is settled. Here's why. The parties know where they stand at that point. Both parties know kind of like what the case is, and they know what's going to happen in court. Again, court really has no surprises. In most cases, civil cases, everything that comes out in court has already been revealed to the other side through discovery, deposition, interrogatories, or investigations. And we'll talk about investigations here in a minute. So both parties already know what's going to happen in court. The question is, what is the judge or the jury going to decide on it? That's where, when a case goes to trial, the only unknown, right? It's when both sides know all the evidence, they know all the details, but they think that it means something different. One party thinks, hey, this means that I'm right. The other party thinks this means I'm right. So there's usually no surprises in the courtroom, for the most part. Occasionally, there's things that come up that refute other evidence, but for the most part, everybody knows what's going on. So what about investigations? Well, investigation is when one party investigates facts. It's not part of deposition getting from the other side. It's not part of interrogatories from the other side. It's not getting discovery of records. It's doing their own, usually private investigation to gather evidence to use in the case. Many times, if the investigation is done correctly, or I shouldn't say correctly, but in a certain way, that investigative report is not discoverable to the other side. So if you're in a case and you investigate the other side, you do surveillance, you pull asset searches, you do witness interviews. If the private investigator is licensed and they are hired in a certain way by an attorney with certain paperwork, that information is only known to the party that hired the investigator. Usually it's not revealed to the other side. So that may be a surprise. So maybe if you know the other side is lying about something and you do a private investigation, you can spring that on somebody in court to ruin their credibility. So an investigation is an important part of a case to get information on your own without relying on what comes from the other side of the case, your counterparty in the case. Now, when I say counterparty, keep in mind that a plaintiff can also become a defendant. Here's why. If you sue somebody, you're the plaintiff, you sue them, they're the defendant, and they can also do a counterclaim against you. So within that same case, they could sue you for something else. Now they're the plaintiff, you're the defendant in the counterclaim. Same rules apply. A lot of times it's a way to negotiate to try to even the playing field if both parties think that they were damaged. And now at that point, you're a defendant in a case. The cases run together. It's not like two separate cases. But if they're related, that's something that can happen. There could be a counterclaim. And now you're a defendant in the counter case and a plaintiff in the primary case. And then this evidence can be used in both cases. What about insurance? Well, if you're involved in a civil litigation, depending upon if you're a business or if you have coverage, many times the legal defense of a case may be covered by certain insurance policies. So check. If you're a business, you may have coverage for legal defense. Even as a civilian or an individual, you may have coverage through your homeowner's policy or an umbrella policy that covers some defense of damages, depending on what it is. So check your policy. It doesn't cover everything, but it may cover defenses. Probably is not going to cover judgments, but it probably will cover your legal fees if it's a covered peril. What about witnesses in a case? Well, there's a few kinds of witnesses. One kind of witness is somebody who knows about that case. They saw it. If there's a car accident, a witness could be the guy standing on the side of the road that saw the car crash. If it is a corporate case, it could be somebody who knows about the activities that happened in that case. That's a direct witness. There are also what's called an expert witness. And an expert witness doesn't mean they saw more than somebody else. It means that they're not necessarily directly related to this event, but they have expertise in that subject matter. For example, if there's a case about a product liability, let's say that somebody's injured using a consumer product, and as part of the case, you want to show that that product was dangerous and that the person had injuries to them. The plaintiff might hire expert witnesses, maybe two expert witnesses. One expert witness could be an expert in the field of that product. Let's say it's a trying to think what would be a good example of a product that could cause damage. Let's say if you buy a pan to put on your stove and you're cooking with it and it catches on fire and damages your house. Well, if that pan was made defectively, made out of flammable material, then that was the cause of it. You may hire an expert witness that will testify, yes, I did analysis of this material, it's flammable, other pans in the general market don't use this material, it's not common practice to do this, right? It's an expert in the field, not related to your case, that can testify in court as to what you're trying to say. They're not going to make up new information, they're just going to support what your claims are, right? Another expert might be somebody that's, if you're injured in the medical field, that says, yeah, these injuries happen because of this. This is what you can expect for future medical costs. This is what you can expect for future, life changes. So expert witness are third-party outsiders who don't necessarily know particulars of your case. They just know about the general area. If there's a car crash, it might be an automotive expert that knows about how safety of cars happen. Expert witnesses are hired by the party that wants them to support their argument. You have to pay them, right? They're a paid service, where other witnesses aren't paid. So if somebody saw a car crash, they're called as a witness. They have to go to court and say, yep, I saw the red car hit the black car, and that's what I saw. That's not a paid expert witness. That's just somebody who saw that particular event. An expert witness is a paid professional, and it also has to be certified by the court. Before the expert witness can testify, the court has to know about them. Why are you testifying? You're an automobile expert. Did you go to college? What's your degree? What's your experience? What's your resume or your CV or whatever the credentials you have are? And if the court's satisfied that you know what you're talking about, they will certify you as an expert witness. Do you want to go to court? Well, any point in this process, it's always a good idea to look for what's called alternate dispute resolution, ADR, where a neutral third party can step in and say, wait a minute. Let's try to work this out before we go to court. Settlement or negotiation is one way of doing that. But the problem with a settlement is that's done between the lawyers that are already fighting. It doesn't put a neutral third party in the middle of it. So a lot of times courts will suggest, even require, mediation or arbitration. Some contracts require arbitration, or a third party neutral third party, in there, that's what they're called, a neutral, will step in, hear the information from both sides, and either try to facilitate a resolution, that's a mediation, or they will force a resolution, that's called arbitration. Mediation is usually not binding. That's a process where a neutral, a mediator, will step in and say, look, this is your claims, here's your claims, I hear them both. In reality, you agree on a lot of things. These are the two things that really you don't agree on yet. Why don't we see if we can come up with some resolution that just solves all this? And it's voluntary. If you're a plaintiff or defendant in a case, you don't have to agree to what the mediator says. You just take it for face value, but they usually know what they're talking about. Arbitration a lot of times is binding. Arbitrator says, look, I heard both your sides. You're half wrong, you're half right. This is what the answer is going to be, and you have to accept that. Anything you can do to stay out of court is a good thing, because once you go into court, whether it's a judge or a jury, it's out of your hands. You don't have control over your case anymore. I'll tell you a story about a case that we're familiar with, and give you a little bit of background. The reason why we know so much about court cases and we're not attorneys is because we have companies that are in several industries. First of all, we own a private investigative agency, and we've seen thousands of disputes over the years: fraud cases, divorce cases, probate cases, lawsuits, litigations, and we've done investigations for those cases and provided evidence in court. We have been an expert witness for parties in court to tell the court what's happening with this case. So we've seen cases from the inside out. We also own a commercial insurance agency, so we see the coverages and where companies get into disputes and they have underwriting coverages for their policy. We're also a certified mediator, so we step in to try to help parties resolve their disputes without going to court. We've also been principals in cases many times. So we have a lot of insight into cases from all the different angles. And we also, in all those industries, work with attorneys quite a bit. We have attorneys that hire us as investigators, and we also hire attorneys for many of our activities. So we see it from the legal side. Again, we're not attorneys. So here's an example of a case that's a good reason why you don't want to go to court, if possible. This case was about a contract for web development, web design. A company wanted to update their website, so they hired a web development company to redo their website. And the cost of this project was quoted at $11,000 to revamp their whole website, do some programming, do a whole bunch of technical things with their online presence. And so they had a contract that talked about what they were doing, how many pages, what the terms, conditions, parameters, scope, scale, all the details. And it had an estimate of about 3 to 4 months to do all this, which was acceptable to both parties. So the deal was it's going to be $11,000. The client was going to pay $5,500 at the beginning of the contract, and another $5,500 when it was done at the end. So half up front, half at the end. Fair enough. So during the course of this development, it got delayed. Now it's 5 months and 6 months and 8 months and 9 months, and so the client's now starting to get nervous because there's really not a lot of progress. So at some point, it was more than a year after the contract, they said, look, you're not getting the job done. The couple things you have delivered to test have been broken. They didn't work right. So let's just cancel this. And the other side said, no, we're not canceling it. So they went another few more months, and there was a dispute over the completion of the job. So the internet company, the tech company, finally said, look, the project is done. Here's the project. Pay us our other half, $5,500. Well, the project wasn't done. The website didn't work. It wasn't completed, but they still wanted their money. And the internet company said, well, you have to pay us, and then we'll fix the problems later. That wasn't acceptable. So both parties basically put their foot down and said, I'm not doing it. Well, the internet company sued the client. But they didn't just sue him for $5,500 for the remaining balance. They sued him for $30,000 because they said, we did extra work on this website development, and you owe us for the extra work. Well, in the contract, it specifically said, no extra work will be done unless approved in writing. Right? It wasn't allowed to charge for more unless it was in writing, which it wasn't. But even though it's in the contract, as a client, if you get sued, you're a defendant, you still have to reply to the lawsuit. You can't just say, forget that, they don't know what they're talking about. Because if you don't show up, the other side wins by what's called a default judgment. If you don't show up for a court case or defend a lawsuit, the other side automatically wins by default. So if you're sued, even if it's a ridiculous lawsuit, somebody could sue you for $1 million because they say you dropped a pebble on their sidewalk and they tripped and fell. Bottom line is you have to address it. Now you can try to get it thrown out of court, but bottom line is you have to address it. So this lawsuit goes to court. Well, obviously both parties thought they were correct. The attorney for the internet company was pushing them. Look, you're going to win. Stick with this case. Over the course of the next 2 years, both parties spent 6 figures, over $100,000 each, to do depositions, discovery, interrogatories, investigations, all kinds of activities in this case. And the client, the company that hired this internet company, they wanted to settle. They said, look, we'll give you your $5,500. We'll walk away from this. Nope, we want our $30,000. What are you going to do? So I went to trial. Well, very quickly at trial, it was a half-a-day trial, the judge said, no, this is not a legitimate claim. You lose, internet company. So they lost. And you might think, well, the client is out the money of the lawsuit. Well, fortunately in this contract, it said if there's a lawsuit, the loser has to pay the legal fees of the winner. So the internet company now had to pay $110,000 to this client company to pay them back for the lawsuit. So you might think, well, at least they got back to square one, but really they didn't, because for 2 years they had to go through this process and do interrogatories and depositions and pay legal fees and do all these kind of things. And the other side now is out $200-something thousand because they had to pay their legal fees and the other legal fees. At any point in this case, had the parties come together and done a mediation or an arbitration or a settlement, none of that would have happened. But both parties thought they were right, and obviously one of them was right, one of them wasn't. Well, what happened in that case? Well, in that case, it may have been that the attorney representing the internet company needed money, and he was pushing to do this case just so he could bill a lot of legal fees. And the reason that that's a hypothesis, allegedly, is because very shortly after that case, that attorney was disbarred for stealing money from another client, embezzling money. So there may be money problems there. But what it goes to show is, even if your attorney's pushing for a case, there may be ulterior motives, right? So at any point that you can divert your case from down that railroad track into the courtroom, that's a good idea. Even if it might cost you more than you think, or you want to have your day in court. I gotta have my day in court. Well, your day in court might be expensive. In fact, the company that was the client in that case, if at the very beginning of the case, if they just wrote a check for the $30,000 and said, fine, here's your $30,000, get out of here, even though in principle that would have been objectionable, distasteful to do, in the long run it would have been better off, because the time wasted over that 2 years was worth more than $30,000. If they could go back in time and get all that back for $30,000, they would have done it. In fact, they also even had more of a loss, because at the end of the case, when they put in their request for, look, you have to pay back our legal fees, $110,000 or whatever it was, the other side said, well, we looked at your bill. Some of these fees aren't legitimate. You paid too much for this investigator, or they billed too many hours, or this is duplicate billing, or this legal service wasn't for this case, it was for something else. So they had to settle for about $8,000 less than what they actually paid, legal fees. So there's a lot of pitfalls. That's what you can expect in a legal case. One last thing to keep in mind is, if you're going to litigation in court, you have a couple options for how the case is decided. You can do what's called a jury trial, which sounds exactly like what it is. It's a jury of people who sit in a little box. They hear all the evidence. They hear the expert witnesses. They hear the testimony. They see the discovery evidence that you present in court. They hear about the interrogatories, and they make a decision. You're right, you're wrong, end of story. Or you can do a bench trial. That's where a judge decides the case. Why would you want to have a judge do it? Well, juries are humans. A lot of times they're affected by emotions or biases, or just maybe they just don't like somebody and they find in the other person's favor. A judge is a little bit more neutral and professional and logical. So keep that in mind when you're deciding how to do it. Now, both parties have to agree on a bench trial, but if you can somehow make that happen, it may be a good thing to do. What is the sequel to this? Well, at the end of your case, what happens if you win or you lose? Well, if you win your case and you're a plaintiff, you'll get what's called a judgment order. And that judgment will say, we find in your favor, you are awarded judgment, damages, recovery, whatever, of X amount of dollars, $50,000, let's say. But that's all the court does. The court does not write you a check for $50,000. They don't force the defendant to write you a check for $50,000. They just give you a piece of paper that says that guy owes you $50,000. It's up to you to recover or collect that money. That's not part of the court case. That's not part of the lawsuit. The lawsuit just says who's right and wrong and how much. After that, now you have to go get that money, and we'll talk about that more in other videos. That judgment you can put as a lien on assets, bank accounts, houses, cars, corporate assets, what have you. But there's another step you still have to do to get that money in your pocket. The judgment itself, you can't bring to the bank and cash it in the bank. You can't deposit a judgment into your bank account. You can use it to take money from the other person's bank account, but you can't just deposit it into your bank account, right? So that judgment is only the first step in getting the money into your pocket, which is what you want to do, really. Sometimes judgments can also have other stipulations, not just money, but it's you have to sign this form, or you have to honor this contract or deliver these goods, whatever, but usually it's about money. Now, last question. What if You are a defendant and you win. Well, if you win and you're a defendant, whew, off the hook. You don't owe anything. No judgment. But you may be out some legal fees. Can you recover that from the other side? Depends on the contract. It also depends upon the nature of the case. You can make a motion, remember motions, to have the other side reimburse you for losses or fees. Doesn't always work, but you can ask for that. What if you're a plaintiff and you lose? Same thing. If you're a plaintiff and you lose, you might be on the hook for other side's legal fees depending upon what the nature of the case is and the contract. Hopefully that gives you insight into how a lawsuit works, what you can expect, what's going to happen to you. Once a lawsuit starts, some things are outside of your control. You're going to have to do and say and appear certain things. The court's going to compel you to do things. You might have to give up copies of your bank accounts. You might have to show up on certain dates and times in court at depositions. So you don't have complete autonomy over your life as long as that case is running. You may be forced to do things, say things, produce things, and reveal things about yourself as long as that case is running. So alternative dispute resolution is always something to look at. Again, you don't want to give away the farm. You want to, stand behind your beliefs, but also don't stand on principle too much where making some minor accommodations might keep you out of risk of having bigger losses, because not every outcome is fair and not every verdict in the case is fair. That's what a lot of people want to believe in. Well, I want my day in court because I know I'm right. Well, even if you are right, the rulings in cases aren't always right. And sometimes people believe they're right where they're not as right as they think they are. Right? You probably have some truth in your correctness, but it may not be 100% either. Just like if you're a sports fan, you watch, a football game, you might see referees make calls that might be wrong. You know it's wrong. You saw him drop the ball. You saw him hit the guy, whatever. Calls aren't always right. Court cases don't always come out the correct way. We've seen it hundreds of times. So even if you're correct and right, it may not turn out that way in court. And more importantly, there may be some things you think you're right about, but you're not. And it may be hard to acknowledge that and swallow that, but keeping those two things in mind is a good way to try to steer clear of the danger, because once you're in court, it's like you're standing on the edge of a cliff. It's danger zone. Don't go there unless you really, really have to, because anything you can do to avoid that danger is a good thing. It's not thrilling. It's not like Law and Order where it's a big, dramatic thing. It's kind of boring, actually. But those are some insights from many different angles of what's going to happen to you in a lawsuit, whether you're a plaintiff or a defendant.